All right. Hello again. This is Ben Hitchcock Cross talking to you today. It's not cold here, although the snow is falling and I should have already been home, but I'm stuck here uh, doing what I like to do, talking with you all. Okay. What do we got? We have the Brady List here, infamous Brady List response. Now, what is this Brady List? It is a list of law enforcement officers in Milwaukee County who have were alleged to have or convicted of criminal offenses or otherwise. I think lying is also a possible reason to get on there. And that's known to the Milwaukee County, who they are obligated by the case law, the Brayton, should know Brady, California, whatever, to tell, give the exculpatory evidence to opposing parties when that law enforcement officer is involved. Okay. So, what we're going to look at today, we'll briefly just skim over the list, but what we're going to do today is just to focus on the public records response by Milwaukee County. Let's do that. I think it's this one. All right. Here we go. This is Milwaukee County, John T. Chisholm. I think, as I recall, did not run for reelection, and another person was handed off. Before him was E. Michael McCann, who essentially handed the job off to John Chisholm, who was his deputy at that time. And then again, although these positions are elected, yeah. And now, look, I'm going to have one hard thing to say about Milwaukee County District Attorney's Office, and it's simply this. Wisconsin and many other states, but in Wisconsin in particular, has a disproportionate proportion of its minority population, meaning just black people, for example, are way disproportionately in the criminal justice system. Okay. And I'm sure many people will have many views on why that is the case. And I've spent many hours in law school studying the differences and compiling data and all the rest. But it's remarkably clear in Wisconsin that, um, again, we've talked about this in other videos, black people, roughly about 5% of the population, their presence in the jails, something like 40 to or more percent. Um, and we can look at it three ways, as far as I can tell. First way is we can believe that black people are have a higher level of criminality than other people. Okay. Second thing we can do is we could posit that maybe the problem is that the laws are race based. I think that may be even harder one to buy than that. Or we can say to ourselves that the people who are implementing these rules are doing so in a race based fashion. Now, that answer gets a lot more complicated, but just on those three things, please tell me if you think that there's some other factor that could account for this disproportionality. Again, it could be any other, I mean, it could be any kind of thing you're talking about. You expect that 5% of the population is, all things being equal, is going to be represented at the rate of 5% in the prison. Fact. 5%, roughly speaking, in the convictions, 5%, roughly speaking, in the charge. And we know this office has control over that, so that's just something to keep in mind. Via electronic only, email only, and that's weird that basically, as far as I know, this came out in to the public in November, but the Channel 4, the news organization, held on to this for quite some period of time, which, fair enough to them. They're trying to make a living, but still. Dear Mr. Biscoe, and who's writing this? This is not even the um, district attorney himself. It's the deputy, Karen Lowell. Not even the chief deputy. She's on the letterhead, though. Okay. I am writing in regard to your public records request sent via email to the Milwaukee District Attorney's main email box. Oh, referred to reference is milwaukee.da@da.w.gov on January 4th, 2024, in which you asked whether Milwaukee County Sheriff's Deputy Sean Baychick is on this office's Brady List. And you make a public records request for a copy of the Brady List. It's always interesting to know how these things come up in the fullness of time. So if it wasn't for the Sean Baychick, issue, whatever that is, and we'll have to look into that. Um, that we'll have to check this out. This is gonna be fascinating because the last time I did something like this was 30 years ago, and we were all on microfilm. So this will be fun. All right. As set forth in greater detail below, I grant your request in part and am denying your request in part. I don't like that language there. Um, I do think that deny, um, but we are producing. If I would say that we are producing these following records, and are withholding the rest. That language there that's problematic about it, as is the records custodian does what is called a review to see if they're public records, if they should be withheld. And this here grant, it just see it. I think it's more grandiose than what is actually going on because these are the public's record. Now, one thing everybody needs to keep in mind, I don't care what state it is in, there are going to be a higher standard in the case law, the law, something else for district attorneys. And generally speaking, we don't give out active district attorney case files or the planning in Wisconsin anyway, the like strategies of the district attorney, even if the case is over, which could mean that the fix could be in or that a case was dropped for political reasons or all sorts of things that we won't learn about. And that's expressly accepted, I think, in most of these rules to protect something larger, whatever that may be. The district attorney collects data concerning misconduct by Milwaukee County law enforcement officers. The district attorney's office started collecting this data in about 2000. This Brady case is from like what? Which requires disclosure. The Brady case, I'm just saying, is like that's. I guess we can find out. Let's not guess here. So yeah, and it's Brady v. Maryland, as everybody knew, and it of course is 63. So are they trying to tell us that it took us until 63, or till it took us some 32 years for the state of Wisconsin to tell the DAs that they had to comply with the Constitution of the United States of America? That's kind of strange. But I guess we can look up State v. Randall's pretty cool. Hold on. Well, they could have cited it a little bit better, but we found it. So let's just read it. And this is from 1995. A defendant, and this is, by the way, a man wrongfully convicted in Milwaukee County by the Milwaukee County District Attorney's Office, is what's going on here. A defendant has a Sixth Amendment right to cross examine witnesses, including the right to attack or impeach the credibility of witnesses by revealing possible biases, prejudices, or ulterior motives of the witness. That's Davis v. Alaska. This right is not absolute. The trial court retains the ability to limit cross examination based on concerns such as repetitive interrogation, obfuscations of the issues, and prejudice. That's pretty good. I'll take that. Randall argues that this is good writing, by the way, setting up the rule, argument from one side, argument from the other side. Here's what we decide. Here's the reasoning why. Randall argues that he was foreclosed from effectively cross-examining Williams because the state failed to turn over evidence that allegedly related to Williams' potential bias or ulterior motive in testifying against Randall. That is, that he was facing pending prosecution in an unrelated felony case at the time of his rebuttal testimony for the state. In essence, Randall intimates that he was unaware of this pending prosecution due to the state's failure to disclose it to him. Accordingly, he was unable to impeach Williams' credibility by arguing the possibility that Williams' testimony was given in exchange for the state's leniency in Williams' pending prosecution. We first note that the state has an ongoing duty to disclose the defense's exculpatory and inculpatory evidence that the state has in its possession, including the evidence that applies only to the credibility of a witness. Okay? The trial court concluded that the evidence of Williams' pending prosecution for armed robbery was a matter of public record and that it was not within the exclusive control of the state. Ooh, that's That's a big gift to the state. Do you see that there? The court that convicted the guy, saying that you didn't have to tell him that this guy was possibly uh, had these charges against him, because anybody could have known that these charges. Okay, I just don't like that, because that's not really the case. Exclusive control. Well, I guess they don't buy it. Further, the trial court stated that Randall could have made a timely search of the public records and discovered Williams' pending charge. We disagree with this portion of the trial court's ruling because it places an intolerable, that's the word, intolerable burden on the defense, namely to continually comb the public record. And I've discovered Williams' pending charges. Any of the state's witnesses are facing pending criminal charges. The burden should rightly rest with the state to provide such updated information, particularly in light of a specific discovery request for the criminal records of the state witnesses, as was present in this action. Nonetheless, we construe that the state's failure to disclose resulting in its inability to preach was harmless error in this case. We reach this conclusion for several reasons. First, our lengthy factual discussion of the evidence. We'll leave that. Or I don't like harmless error. I really don't. I really don't. But we'll leave it at that. Okay. Getting back to there. So, based on that, now they're keeping these lists, even though, but for potential charges. See, what I think doesn't make sense about that is it sounds like they were supposed to be, for any charges, they were supposed to have, since 1963, they were supposed to have told everybody. So this is apparently any pending charges. Okay, got it. So that's the problem, is it sounds like they weren't collecting any data before 2000. And even in 1995, they had this case that told them that they're supposed to keep pending charges, and they didn't do that again for even 5 years. So that's troubling now. But okay. The data collected on this list includes information about officers who have been charged with criminal offenses and certain forfeiture violations, such as first offense intoxicated driving, which is not a crime in Wisconsin. In its native form, the database may also contain case referrals involving law enforcement officers for which prosecution was declined because of insufficient evidence. Case referrals involving law enforcement officers that are pending investigation. So this one says charges pending. Pending charge. But for some reason, these guys have they have extra information. This isn't just pending charges. They keep more than that. It's also weird how they say, we understand this to mean what you say, which sounds like they're defining away what other things too. Law enforcement agency regarding departmental findings of untruthfulness. Well, that's significant. Or violations of other departmental standards of conduct. District attorney notes regarding calling named law enforcement officers as witnesses, and Brady and Giglio materials provided to the defendant regarding the credibility of certain law enforcement officers who are called as witnesses in cases prosecuted by the district attorney's office. I decline to answer your question as to whether MC and Milwaukee County Sheriff's Office Deputy Sean Batchick's name appears on the list. That request falls outside the public records law because it calls for information rather than a record. That's just being an ass, sir. Ma'am. Ma'am. It's just being an ass. I grant your request for a copy of what you have characterized as the Brady List in part. That is, I enclose a copy of the record, but I redact it, withholding certain information consistent with controlling legal principles set forth below. In Wisconsin, prosecutor files, whether open or closed, are privileged and are exempt for disclosure. That's Richards v. Faust. That's pretty standard. Records which are integral to the criminal investigation and prosecution purposes are protected from public inspection under Faust. That's true. Faust stands as a blanket exemption disclosure. That's true for district attorneys' prosecution and investigation files. Nonetheless, district attorney's office has made exception and released records have been publicly filed and are part of the public record. Doesn't make any sense. If they've been publicly filed and they're part of the public record, then it doesn't make any sense. They're not then protected from public inspection. That's absolutely inaccurate. I do not agree with that paragraph whatsoever. That even if they put your parts of the case file in the public record, that those are not public documents and subject to blanket exception, wrong. Don't agree with that. In addition, attorney work product, including notes, material information, mental impressions, and strategies, an attorney compiles in preparation for litigation is similarly accepted from disclosure under the public records law. Okay, that's Lori Lubinsky, by the way. Here's what I see for versus school district of Sheboygan Falls. What I would say on that is simply this. I didn't get the sense in what he just said here that this is their own language, saying that case referrals involving law enforcement officers that are pending investigation, records obtained from law enforcement agencies regarding departmental findings of untruthfulness or violations of other department standards of conduct, et cetera, et cetera. Okay. Now, the point, I guess the distinction that I would make is putting these documents on a so-called Brady list, is that in preparation of a litigation or something else? Because I kind of think it's something else. I determined that the parts of the reference above which contain information compiled by our office from court filings and other records in the public domain are subject to disclosure under the public records law. I determined that the balance of the information on the list described above, including any information that about referrals for which the prosecution was declined, law enforcement department's findings. So if we find that somebody's untruthful, we're not going to give that to you. Got it. Based on those determinations, I have enclosed a redacted listing. It's not redacted, it's edited because there's no we'll just look down here. There's no redactions on this list of any kind. It's changed, it's altered. It's an altered list. I mean, I don't know why they're saying that. Redacted list of the law enforcement officers who appear on what you have categorized as I mean, are they from Mars? Why are they talking like this? This list has been redacted to remove all records. It's been altered to remove all records other than those which relate to the law enforcement officers who were charged with a crime or forfeiture action. I really hope they sued them on shit and got everything. I really do. Maybe that's what took so long. Records relating to individuals on the list who were referred to for prosecution but not charged have been redacted as exempt from disclosure under Faust as records integral to the criminal investigation. Well, but so that's the problem is those records might have been integral to the prosecution, but putting them on the Brady list was not integral to the prosecution. This is the tactic of splitting things up into micro pieces and not looking at the whole and then declaring that the piece to be exempt. Agencies regarding Department of findings of untruthfulness or violation of other standards of conduct, district attorney's notes, and Brady Giglio material providing to the defendant regarding the credibility of certain law enforcement officers who are called as witnesses to prosecute have been redacted under Faust as records integral to the criminal investigation and prosecute. What? And as attorney work product or both, this is okay. I fired so and so because he's a liar. That is a prosecutorial record or an attorney work product? Wow. Please take special note that I am providing the enclosed list with several additional important qualifications. First, this office needs no representations to the accuracy or completeness of the report. We could be liars. I don't know. What do you mean it should be confirmed? Don't you do a good job? Like, what are you talking about? Second, the report does not contain case numbers or other pertinent information regarding law enforcement officers charged with federal crimes. Well, why not? Third, the case dispositions column should be read to reflect only that the officer was convicted of some charge, not necessarily the charges in this report. The problem is that they still haven't produced. This is not the record. This is something they created for the public, while saying that they don't have to simultaneously saying that they don't have to create this for the public. Um, that is, boy howdy. I'll have to look into what they actually said, did, or respond to on that. But that's just the response from Miss Catherine Lobel, Deputy District Attorney for the Milwaukee County District Attorney's Office. So there we go. There you go. Attorney work product. We've heard that before. We've heard that before. But you tell me if the chief says that you lied and fired you for lying, that's somehow secret. That's not a public record because it's was given to the district attorney's office. It's something they did for prosecution. It's a prosecutorial file or an attorney work product. That of the ones that make no sense, that one makes the least sense. Make that make sense, would you please? And stick with us. We'll keep you informed.